pour porter des micros, parce qu'on a absolument besoin, quand les gens vont poser des questions, de leur amener un micro.
Je fais rentrer maintenant.
Oui, oui.
Ça vous laisse asseoir.
Exactement. Please come in. Okay, I think we're almost complete, and it's my pleasure to welcome you today to this wonderful location. I hope you appreciate it. You can enjoy the view a little bit. Afterwards, we'll have to close the store to all of our projections. So my name is Pierre-Yves Lastic. I'm the organizer of this event. So I'm really happy to welcome you numerous to this event. It's the third time we organize it. 2 years ago, we had the first one with around 100 participants. Last year, we had 123 participants, which was a progress. Already, we have over 150 participants to the event this year. So it sounds like there is a growing interest into this subject. I spent 30 years of my life in the pharma industry, and from 2005 to 2019, I was a privacy officer, first in the R&D department, then as a global privacy officer for Sanofi. And one of the major issues we had to face when organizing clinical research was the multinational aspect. Today, clinical trials need to be multinational. And even if we have the same regulation in Europe with GDPR and with the clinical trial directive, who became the clinical trial regulation, the application of this regulation is very different from one country to the other because health is not part of the EU mandate, which means that the regulation comes from IT issues, from the regulation of medical products, but the health is regulated very differently in each country, which means that we have a variety of different situations. If you run a clinical trial, something that you do right in France might be wrong in Germany, or the other way around. And so there was always a necessity to define best practices. How do you work in this multinational environment? And then on top of that, we have now a big European regulation coming. We will be talking about it today, the European Health Data Space, where data from European patients should be accessed by citizens and by companies doing medical research or medical device companies, which means that we need to have a secure environment for this data and to find harmonized ways of dealing with it within Europe. And of course, we have seen with the COVID crisis that in general, diseases don't stop for borders. And that means that Europe is not alone in the world. And we need also to deal with many external partners in the US, in China, in all other Asian or African countries, and which means that we need even to expand furthermore. When I was looking into the issue of health data, there were very interesting conferences and seminars organized in France and in Germany and in Switzerland and in Italy, but always local. So the idea came up when I became the Secretary General of the European Federation of Data Protection Officers in 2022, that it was needed to have a group working on this subject, and this group should be able to meet once a year to exchange. And that's how the first European Health Data Protection Congress was organized. And the language is English for practical reasons. I know that for some of you it might be a challenge, but because, well, within the European Union or within Europe in general, we're used to different type of accents that should not stop us for exchanging. So the language is English, and also because most people at least have a passive understanding of English, but probably better in reading than hearing, we will have also a number of slides that summarize a topic so that you have something that you can rely on. The topic of this conference, we had a lot of interest for how to keep data confidential, technical means. And of course, at the beginning of the year, the European Data Protection Board issued a guideline on pseudonymization, which is the favorized methods used in clinical trials for keeping patient data confidential. So we are happy to have Gwendal Legrand from the EDPB with us, and a number of people participating in the elaboration of this guideline. Giuseppe D'Acquisto from the Italian Garante should be joining us. He's coming from Brussels. I hope that he got his train and will be with us at around 3 p.m. Great. Thank you very much. So we will have the two keynote presentations on the topic of pseudonymization, anonymization, or synthetic data. And we will start with a lawyer, because what is interesting is in practice, how does case law looks like when it comes to pseudonymization, anonymization. And Patrice will be presenting us an overview of this case law that would be a very good introduction afterwards for Giuseppe, who will be presenting the EDPB guidance. After that, we will have a number of experts that will join the panel to discuss this very topic. Now, concerning, I have a few practical points. As you can see, the timing is very tight. So I will try to be always there to remind people that we should try to stop in time. This evening, we have, after the last presentation, only a short period of time to go to the cocktail and networking offered by Clifford Chance, which is, well, for a Parisian is not too far away, but we thought that having a bus would be a better idea. So there will be a shuttle bus to pick you up at the entrance and bring you to the cocktail reception at 7:15 p.m. Another thing is all interventions here are recorded. And because we are very much interested in your questions, in order to get the sound on record, we will ask you to wait for the microphone when you ask a question so that everybody understands. So I think it's almost 2:15, and it's my pleasure to invite our first speaker, Patrice Navarro from Clifford Chance, to start with this first presentation. Patrice, the floor is yours.
I'm waiting for the blind to close. It's extremely noisy. Oh, thank you. So, hello everyone. I don't see you anymore. You're in the dark. So I'm Patrice Navarro. I'm from Clifford Chance. I'm a partner in the Tech Digital Group, doing data for the past 20 years, unfortunately. That's quite a long time. First, I want to thank Pierre-Yves and Michael. I think everyone in this room was waiting to have a nice forum to discuss health data. It's really hard to find and to have proper discussion regarding this subject that is far from being simple and extremely complex. So thanks to them, we are all there, and it's a big success. And I guess this Congress will grow and grow and grow, and we will have many interesting discussions in it. I will start a little presentation on anonymization, pseudonymization, the case law. But do not hesitate to intervene, put question. Always happy to do that in a more dynamic way, and interested to understand your comments, your view. And maybe do not take everything I say at face value. When I started with my former boss 17 years ago, the law firm I joined at that time, he asked me if I was doing data protection. I said, yeah, but you know, it's not that interesting. It's not very, very sophisticated. 17 years ago, that was the case. In the former law firm where I was in, we were just following guidelines, cutting and pasting guidelines from the CNIL. And I've been proven wrong. It has been much more complex and interesting than I was expecting. A few years after that, there was a cancellation of the safe harbor, for those who remember. We did the first webinar to have 4,000 attendees during that time. And nowadays, we are speaking about health data processing, when processed responsibly, save lives every day. Health data is innovation and saving life of the patient, making life of the patient better. So that's really important. And one of the key points is when you can and how you can process it. And of course, are you under the GDPR? So that's the point about anonymization and pseudonymization. There's a lot of views that are not exactly based on legal realities when we talk about anonymization and pseudonymization. Actually, for the past 20, 30 years, even more, everything, it's not just black and white about anonymization and pseudonymization. It's based on identifiability. So that will be the point here. Getting back on the core subject here, it's identifiability. It's a practical test, and that's what I want to advocate. It's really a question of practical test, not just theoretical view, not dogma. It's just in practice, it's basically, bottom line, a question of identifiability. And that matters a lot. It matters for hospitals, it matters for farmers, for medical device manufacturers, and nowadays with EHDS, it will matter a lot for health data access body. But I won't discuss too much about this because there will be a session about EHDS. So I was saying health data is saving life. It's saving life. It's also a better care. Think about linking imaging, improving diagnosis. But it's also not just innovation, it's also safer product, real-world evidence, real-world data supports vigilance. It's also very important for AI models, avoiding bias. We'll get back to AI. Of course, that's a big part of the subject. It's also about efficiency. So data reduce waste in various pathways, but also in procurement, simply, very materialistically. It's also important for procurement, which is a big subject in your sector, in the healthcare sector. And if properly collected and processed, you need, of course, a lot of data, but you can do a lot with the same data asset. That's one of the big things with correct pseudonymization, minimization, and until anonymization. It's reusing, putting the maximum value from your data assets. That's a question of quality and governance, which will link to reuse. It's important. You have an asset, you should use it, and use it as much as possible. But let's not forget what we all do here. So we do data protection. We do data protection, and sometimes it's also something that is forgotten. I'm always telling to my clients, in case of doubt, you have done this very sophisticated DPIA. It has taken weeks, if not months, to achieve. But at the end, put yourself in the shoes of the data subject. Are you protecting their data? Are you infringing their rights, their freedom and liberties, as we say? We can do a lot while thinking about that, but it's something not to forget. It's really, really dangerous to just look at the DPIA and you have a bunch of cells that are green, you have a bunch that are orange, maybe one or two red that you manage to kind of degrade into orange. But at the end, are you protecting, correctly protecting data subject rights, not just ticking boxes? That's one of the key points. And that's why anonymization, pseudonymization, and minimization are here for. So, basic concept. I was saying we're always thinking in a very black and white terms. There's anonymization, pseudonymization. Just for everyone, anonymized data will be out of the GDPR. Pseudonymized data should be personal data, and if it's personal data, that will be in the GDPR. We'll get back to this very specific distinction. But what we have learned, and in fact that has always been the case, but we are learning through the case law that I will go through in the next minutes, that maybe personal data is not personal data for all the recipients. There is boundaries. It's possible to see boundaries. It's very contextual. It depends on technology, depends on cost, it depends on the legal definition, of course, but I think there's one thing to remember. It's still hard to implement in practice, but it's subjective, there's subjectiveness. Personal data is not personal data necessarily for all recipients. And we need this distinction because I never wanted GDPR to be seen as a barrier to innovation. It's not. I will just take from a discussion I had with a journalist from the Financial Times. He said, in innovation, we need safeguards, always. Without safeguards, there's no innovation. And he took the example of a car. You can have a car, a very, very, very fast automobile. But if you've got no brakes, you won't be able to take any curves. You will just end up in a car accident. So here, GDPR is not a barrier to innovation. It's just a few brakes that are needed to be able to go fast in an efficient manner. So during my short presentation, I will get back to what is the actual legal test. Let's get back to plain English, explaining that in plain English. What is the legal test about anonymization or pseudonymization? Then a few words about what I believe to be the 4 major cases in terms of case law that are shaping our views, our principle applicable to anonymization. Of course, I will have to talk about the EDPB versus SRB. It's a given, and I won't be the sole person, the sole speaker, I think, during this Congress to address this. And then maybe get back to feedback, practical experience, operational playbook on what to do, where everyone is confronted. And maybe I will finish on a hopeful note on what I expect or hope that we will get from the authorities and where we are going. In terms of definition of personal data, anonymization, pseudonymization, I'm always saying that 2024, 2025, maybe 2026, we are in the gray years. We are expecting more guidance, and hopefully that will be easier in the coming years to determine precisely if you've got personal data or not. So I was saying that I will get back to the real test in plain English. What is the real test? And actually, it's not new. I think you can get back to the 90s, where there was always a question of re-identification, a question of reasonably likely risk of re-identification, a measure of cost, time, technology, and legal constraints. It was already in the GDPR in recital 26. So it's far from being new. It has never been, and I'm sorry to say that for those who may have different views, but never the GDPR, nor the Data Protection Directive, never said that personal data, it's if someone somewhere can re-identify at any cost. We never said that, this maximalist or objective view. It was never the case. Maybe it was at the end what was applied for years, but that was not I believe, the intent, and that was never what was written into the GDPR or in the Data Protection Directive. And even this reasonably likely, I will get back a lot on reasonable likely. It's a key notion, of course. So the reasonably likely identifiability test did not start with the GDPR in 2016, but it was already there in the Data Protection Directive. I love my history, sorry. It's if you know what happened in the past, you're better at forecasting what will happen in the future, I believe. So if you know the different variation, update, and modification of the law, it's a good way to anticipate what can happen in the future, and it gives you a lot of examples of what you can do in practice, in fact, through all this discussion. So I was saying it was already in the directive. It was already about reasonable, practical means, not theoretical possibilities to re-identify. It's like that since 1995. And anonymization does not say no one can ever re-identify. It's no one can reasonably re-identify. Well, of course, pseudonymization, there's a possibility of re-identification. There's possibly identifiers directly or indirectly. So in that case, it's personal data. And just to finish on the history part, even in the French data protection law from 1978, where most of us probably have forgotten, but we were not using the term personal data. It was nominative information. But but with a reform in 1994, in 2004, to implement the 1995 EU directive, we changed to personal data, which says a lot about this definition of personal data and the various ways to determine what is anonymized data. So that was the situation 20 years ago, the GDPR, but more recently, in the past 10 years at least, I think the notion have moved. There was an evolution. So let me talk about a few case laws that were, in my view, particularly key in understanding the notion of personal data as a whole, and of course on anonymization. So the first case, you probably all know about it, it's Breyer. It's from 2016. It's where we discovered that IP addresses from a website can be personal data. But let's remember that was also one of the first cases to clearly say, or to put the question, whose hands? Who has the data? In which hands is the data? And is it personal data in those hands? So do you remember this case fully? You can correct me if my memory is bad, and do not hesitate to enter in. If you raise your hand really and you shake like that, I may see you despite the lighting. So Breyer, it's about a dynamic IP address that can be personal data for a website operator. So if that operator has lawful, realistic means to get extra information, for example, via the internet service provider, the ISP, to identify the user, then the question is it reasonably likely? We should take into account the cost, time, the available technology, and the legal barriers. It was already into Breyer 10 years ago, 9 years ago. So it's already said that if law prohibits identification, or it will take disproportionate effort, it's not reasonably likely that there will be re-identification. So the same data can be personal for one party and non-personal for another. So it's this label, personal data or not personal data, follows the realistic means available to the party processing the data. It was already the case. And if I move to the year after, the Novak case, 2017, it's where the court decided or confirmed that how information can be considered as relating to a person. So what the court said in that case, in the Novak case, it says that information relates to someone by its content, purpose, or effect. So it was about exam answers and the examiner comments. So maybe it will ring a bell if you're very familiar with the SRB decision. It's not that new. It sounds very similar to the Novak case. It was already about comments, and here it was relating to a candidate. And the examiner comments can also relate to the examiner, him or herself. So even opinion can be personal data about their author. So in our real world, it means that margin notes or the clinician comments that can relate both to the patient or to the professional who wrote them can be personal data about them. It's also a takeaway in the SRB case. The third case I wanted to mention was the IAB case, IAB Europe. It's closer to us, 2024, where you remember also that it was about a TC string. So it's a transparency and consent string that you have if you have a CMP for your cookies in online advertising on the website. So this TC string, if you already have seen one, it's just a compact, like machine-readable code created by a website in the consent interface. So it's not something that you can read out and find anything about it. But it records the user choices. If the consent was granted or refused for some of the cookies or for some of the online advertising. So it's passed along in the chain. And what the court said in the EDPB Europe case. So it says that this TC string that you cannot even read aloud can be personal data when it can, by reasonable means, be linked by an identifier. And the identifier can be the IP address simply in that ecosystem. So the fact that a standard setting body like the IAB does not itself hold all identifiers does not make the data non-personal. You have to look at the realistic means across the processing context. So it means that a code, and we know that nowadays, can be pinned, can be attached to a person, and in that case, that will be personal data. And the last old case I wanted to mention is the OC case, and for some reason not known to me, the OC case is not as well known, but it's a landmark one. So it was also last year, 2024. And just to unveil the bottom line already, it's about insignificant risk. That's a notion that is quite often forgotten. One of the key notions when you're trying to assess if data is personal data and if there's identifiability, it's the notion of insignificant risk. And this OC case from last year was very clear. So let's just on the facts. So that was the OLAF. So this is the EU Anti-Fraud Office, which published a press release on some suspected research funding fraud. And the question put to the court was whether the details in that press release amounted or what could be considered as personal data because a reader could figure out who the person was out of a press release. And what the court said. So the court said that re-identification must be reasonably likely in the real world. That's very important. When we are fighting this maximalist objective approach to personal data anonymization, reasonably likely in the real world. So the court repeats that a method is not reasonably likely where identification is prohibited by law or require a disproportionate time, cost, and labor. We are getting back on the disproportionate effort. In such a case, the risk is insignificant. So the court faulted the lower court for setting the bar too high and for minimizing the practical routes to identification. So there's really a need to assess, and I will enjoin you to do it each time you can, each time you have the case, each time you have the question. Do not stop at saying, yeah, it's pseudonymized data, it's personal data. And it's really a question of identification, re-identification in the real world. What are the practical routes to identification? I love this wording, practical routes. And so the question is there an insignificant risk? And what an insignificant risk is according to the OC case? Doesn't mean that just that. But in that case, we can rely on this. The risk is insignificant. It's if re-identification is prohibited by law or would require disproportionate effort. unfortunately, we don't have a definition of disproportionate effort, which clearly need a bit more, and that will be in my hopeful notes for the future. But once again, we are fighting that we should not assume anyone could somehow identify a person. You need to make an assessment. And there's no form for this assessment. You can do it yourself. You have a few forms that are available, actually. The Health Data Hub published one a few years back where you can do your assessment on identification. Not sure about the conclusion from the form itself, but at least there's some basic forms that you can use as an inspiration to do your own assessments on risk of re-identification. So then, getting back closer to us, getting back to September, to last month, about a few weeks ago, to the last case law I wanted to mention. It's the, of course, SRB case, EDPB versus SRB case. Just for everyone to remember the facts, the SRB shared some commentators' statement with Deloitte after some pseudonymization. And the European Data Protection Supervisor kind of reprimanded the SRB for too much transparency, saying that it's pseudonymized data and it's not it's personal data, and it has to be protected as such. So in that case, where the decision from the General Court was annulled, there's certainly three takeaways. Some of you probably know them, but the key takeaways for practitioners, at least, from the SRB case. Similar to previous cases, opinion and comments can be personal data about their authors. So it's probably something to repeat to our operational teams, to everyone. Just a comment can already be personal data for their authors. Very important, and sometimes overlooked. Transparency is controller-centric at collection. So you have to inform about recipients, categories of recipients at least, when collecting the data. So you are the controller, you are collecting personal data. Maybe you will provide the data to someone else, which may be considered as not receiving personal data. But still, as a controller, you have to inform. It's front-loaded. You have to do it priorly. That's not so easy. And the last one, of course, it's pseudonymized data are not personal data in all cases for every person. For me, it was kind of obvious, but unfortunately, it hasn't been always the case for years. But let me repeat it: pseudonymized data are not personal data in all cases and for every person. It really depends on effective measures and whether the recipient has means reasonably likely to re-identify. In the healthcare sector, it's not that easy because there's many ways to identify. But still, we should do the assessment and not just stop at it's pseudonymized data, full stop. I will stop here, and end of the story. There's an assessment to make because personal data for a controller might not be personal data for a recipient. On top of this, and getting back a bit more in the past, just by a few months, and that will be certainly updated, notably in light of the SRB case. But these EDPB guidelines from from early this year, at least the version for public consultation. What are they bringing? I think they help. It's clearly going in the right direction for practitioners like myself. And it's kind of saying very similar things to SRB. Just the other way around. Pseudonymized data, according to these guidelines on pseudonymized data from the EDPB, remain personal data if anyone can link back with additional information, if you can link back to a data subject. That's exactly what we have been saying and the other way around. Can you link back or can you not link back? It's extremely basic, hard to make, but pretty basic. But there's also something that is very important for innovation. We recognize that pseudonymization, which I will link to minimization once again, pseudonymization reduces risk. It supports legitimate interest, purpose compatibility. It's necessary under Article 25 on design by default. So for innovation, thinking about pseudonymization is very important. Maybe these guidelines are not saying exactly what we would like for them to say, but it's kind of confirming that you may have to process a lot of personal data, but one of the key measures, one of the key protection is pseudonymization as much as possible. So getting back to the very beginning of my speech, it's pseudonymization. Maybe it's not anonymization in many cases, but it's a good way, the right way to protect the data subjects. So we have seen the 4 cases, Breyer, Novak, OC, IAB. It's confirming notions, principles that we knew about. SRB is confirming a bit more and maybe shedding a bit more light. The EDPB guidelines are shedding even more light. But at the end of the day, I'm a practitioner. I'm advising how to do things. So how you have to do that. So my advice here, and what will be the playbook? When you have health data, really hard to make sure that it's anonymized. But how do you make sure that you're protecting the rights of the data subject? So my first advice is, you remember this notion of whose hands? In whose hands the data is? So you have to classify by hands. So for each disclosure pass, my advice is to record who could realistically re-identify. Today, I mean, once again, it's a real test. Getting back to the OC, the Olaf case. Today, who do you or your recipients can they re-identify? And it's a question of legal prohibition, contract. Do not forget that you can get some guarantees and put obligation on the recipients not to identify. That's under contract. But there's also other ways, like key custodies of the codes and some IT separation. I'm also on IT separation. I'm also a big believer in technical solution. The answer is not always from a legal standpoint. There could be legal plus technical solution. So making sure, and it's something that you should have in your DPAAs, in your assessment, that there's some separation, making sure that the table, the concordance table, the keys are kept separately. So you can make sure that access is correctly managed. There's a number of cybersecurity actually measures that you can put in place. And for that, I will advise to use this wonderful guide from the ENISA. I think it was published in 2022. So there's a guide from the ENISA on pseudonymization and the safeguards to put in place. We really advise you go look at that and see what kind of measure you can do to reach a proper level of pseudonymization. Once again, maybe it won't be anonymization, but you are making sure that you are protecting the personal data that you have, and maybe the personal data that you receive, and the personal data that you're sending away. Then there's this difficult point of transparency. You have to make sure that you state recipients or category of recipients at the very beginning, at the collection point, and even if they receive pseudonymized data only. So it's, once again, protecting the data subject is also informing them. It's also protecting you because you have done things correctly, but we are not here to check boxes. We are here to improving protection. And my last advice will be to document all of this. You can document, you can assess also the risk of re-identification. Use pillars, the effort in terms of cost, effort in terms of time, effort in terms of tech. Do you need to hack 128 encryption key to be able to re-identify? And then the legal/contractual factors must be in when you assess this reasonably likely assessment. And this assessment, I will also recommend to revisit and update them each time necessary. Do not just put them in a drawer or in a file on your computer. It has to be reassessed. So we are here to fight some pitfalls and myths. You have seen that during my speech. I'm trying to fight all these myths that we have heard. Once again, pseudonymized data is not always personal data. It's too absolute. It really depends on the recipients and the means and the controls. But there's also the other side of the coin. Anonymization, according to our operational teams, is usually seen as meaning zero risk. But you have to get back to them. Is it really anonymized? Do they understand that if there's a likeness, a risk of re-identification, if it's not impossible in theory, there's always a little bit of risk. So do not treat anonymized data without any care in the world. There are still some precaution measures, even once you have reached a threshold of anonymization. And then there's transparency. Also a big believer in information. Transparency cannot wait until we share. We have to inform early on. I said it's front-loaded. It should be at the controller point, at the collection point. I know that it's far from easy, but we have to inform. So it's a lot of work and it's a lot of thinking. Data protection notices are not just templates that we put on our website. It has to be carefully thought about and updated. So I will finish on my Christmas wish list. Waiting for the new EDPB guidelines and globally, what I really would like is to have operational criteria for anonymization. So I really would like to understand the concrete threshold and scenarios that we could share, at least across the industry. We all know that when we are making our own assessment on our side, there's always a measure of risk that someone will make an assessment that is different from ours. So I would like concrete threshold, scenarios, a kind of harmonized evidence standard for when re-identification is reasonably likely. it's always on this reasonable likely. What does it mean? If you look at some assessments that are available, some templates, you understand that the reasonably likely is considered as a synonym for not impossible. But it doesn't work. If you do a risk assessment, you cannot say that the only correct answer to the risk assessment is zero risk. A risk assessment where the answer should be zero risk is not a risk assessment. So there will be a measure of risk always. And my last wish is probably to have some examples. I love examples. And in the I don't know, some FAQ, some example on how to do that will be wonderful. I have other wishes, but let's not go too far. Having an expert certifying anonymization, similar to the HIPAA experts, will be nice, but maybe for a next step. I think I'm kind of running out of time. I am always happy to talk a lot about data protection nowadays and all this subject. So if you have any question after that, do not hesitate to tell me. I think we are moving to the next speaker, which is Giuseppe. Giuseppe arrived, or?
Thank you, Patrice. Well, actually, we are. I just received a note that Giuseppe is in a traffic jam, right? So, which is pretty normal in Paris. So we have to show some flexibility, and we will start the panel when Giuseppe arrives, and we will give him the opportunity to make his presentation and continue the panel afterwards. And because you're part of the panel, I think you will have the opportunity to answer questions. Good. And first, an applause for Patrice. Thank you. Everyone. So now I will ask the member of the panel to join us, and Winnie Dongbu from My Data Trust will moderate the discussion. I don't know if tu te mets ici ou tu...
So I think we can start, right? Okay. So hello everyone. We are really pleased to be on front of you today to discuss about this interesting topic. So as already said by no? Okay, perfect. So sorry. So I will start again. So I'm Winnie Dongbu from My Data Trust. I'm a senior data protection lawyer, and I'm also a PhD student working on strategic data and anonymization and the impact in medical research. I'm really pleased to moderate this panel, and today I think we have a great one with great panelists. I will start. I mean, you already heard from Patrice Navarro, so I will start by presenting Marta Siemasco. Who is from Novartis, a global operation director, specialized in data privacy, digital, and AI. We are pleased to be here with you. You will give a flavor or perspective from the industry, so that's why I'm really happy to have you there. We will have Gwendal Legrand from the EDPB, who is deputy head of the EDPB secretariat. I think it's the right one. So you will kind of represent the EDPB, but you will talk more about how there's an harmonization regarding this different view, also from data protection authorities, from the Court of Justice, and so on. And we will have Michael Will, who is head of the Bavarian Data Protection Authorities, who will give a bit of view on the approach in Germany, because I mean we had some cases with laboratories claiming that they want to rely on the EDPB decision, and they consider that anonymization should be assessed based on the data that they have themselves, and they consider that this is anonymized. So I would be really interested to hear your view as a data protection authorities and how you manage this in practice. So we are missing, unfortunately, Giuseppe from Guarantee, but as Pierre said, I think he will catch up and will be able to ask some specific question. My first question will be directed to you, Michael. We heard about Patrice, about the position of the CJ, about those case laws. I'm wondering, do you consider it? Do you have like scenario? Do you have guidance that integrate that approach? Do you believe in that distinction between absolute, like risk zero of anonymization, or a more relative one, where we need to assess the risk based on the recipient of the data? What are your views? What are the views of the authorities on that?
First of all, let me thank you for inviting me. It's an honor to be here, and it's a really impressive audience, and I'm a little bit frightened that I'm the only non-expert in protecting health data. I'm a generalist, and so I will come back to your question with a reference to a case which doesn't deal with health data, but with something different, which is also highly protected under GDPR, with biometric data. And the idea how to use it for a new service. The service is also known in France in the meantime. It's called the World Service, which is a little bit frightening many people because they are doing iris scans, and then they offer the opportunity to prove that you are a human. And by the way, they offer also certain cryptocurrency, and that makes all these things a little bit spooky. We are lead authority for this company, and so we had the opportunity to align with all our European colleagues whether this company, which has established a very, very, elaborate technology, has reached the point of anonymity, considering that they use biometric data, which is a priori something which is very hard to anonymize. At the end, you can see it in one of the guidance EDPB gives us. It's a register of cooperation cases. And there you will find understanding of where do we come to the point of anonymity, which is neither absolute nor relative. It's at the end, as Patrice said in a very excellent and for me agreeable way, it's contextual. Mm-hmm. It depends on the situation. It depends on concrete circumstances, and with all the other authorities involved, we came to the conclusion in this World, or WorldCoin was the former name, case, that the result of anonymity is not yet there, in spite of very complex technologies. At the end, I think we should go out this evening with Patrice's recommendation to lead the OC decision, which is, for me, the most practical one. Because you see on a very, very simple case what is your position when you do the identification test, when you assess the risk, because Olaf did not a good job. In this situation, they didn't consider whether they are journalists and many other people who might have additional information. And that's why my recommendation for you, when you want to sleep well this night, please read the OC case.
Okay. I mean, that's quite interesting. I would like to have a little precision regarding that discussion you had with other authorities. Was it authorities in Germany or European one?
No, saying that we are the lead authority means that we had the discussion with our colleagues in Europe. Okay. And so this case, when you find it in the register, and I will be happy to share with it afterwards, is that you find a practical assessment on the basis of all the positions of European supervisory authorities. That's why I always recommend to use that register and to see what is already done in a practical way. It's not always easy to come to something you can take away. You have a perfect learning because you have to read a lot. But that's why they are practical cases, and they are, at the end, stable.
Okay, maybe I will just give the floor to you, Gundal, to tell us more about that register and maybe other mechanisms you have to, make sure that there's an harmonization when it comes to interpretation of this type of, topics, subject like anonymization. Thank you.
Yes, thank you, and hello everybody, and thank you for inviting me on this panel, and congratulations to the organizers. I'm born and raised in Paris, so I know how exceptional it is to be able to meet in a place like this one. So I work for the EDPB Secretariat, and as you know, the EDPB is the group of all the European data protection authorities. And before the GDPR, it was the Article 29 Working Party, so the same people, the name changed with EDPB. We have different types of instruments to create consistency within Europe between data protection authorities and build consensus, because at the end of the day, this is what it's about. It's about having a common interpretation, a common understanding of a question. The different instruments you see in the types of documents that we adopt. So one of them is the guidelines that have been mentioned before. What we call the guidelines today is what the Article 29 Working Party was calling the opinions before, because under the directive, the word guideline didn't exist. The guidelines is the guidance how to apply the law. So we have these guidelines on pseudonymization that have been published. They have gone through a public consultation. The final version after the public consultation is not released yet. And we have recently announced that we would do a stakeholder event on the SRB case before the end of the year. And this will also feed the input to the final version of the guidelines on pseudonymization and the guidelines on anonymization, which are currently in preparation. We have all the tools in GDPR for the cooperation between data protection authorities. So that's the articles 60 to 62 in GDPR. Michael was referring to some of these tools. When there is a cross-border case or when you need assistance from another authority, GDPR has instruments to involve the other authorities so that at the end of the day, you only have one decision taken by the lead authority, but that is binding for all the authorities in the EU. We can also do joint investigations. That's Article 62 of GDPR. And then we have the consistency articles in GDPR, which was 63 to 67. And in there, you have the binding decisions. So when the authorities don't reach an agreement on a case, in that case, the EDPB intervene to do the dispute resolution, okay, and force the lead supervisory authority to change its draft decision. So that's the dispute resolution, which is Article 65, and there's the urgent binding decisions in Article 66. And we have the other instruments in Article 64, and Article 64 has two types of interesting things there. You can ask for, an authority can ask the EDPB a question of general application. So it's a bit like when a high court at national level asks a question of interpretation of the law to the Court of Justice of the EU. We're not the Court of Justice of the EU, but it's just to give, to explain the meaning. And in that case, the DPB will prepare an opinion that is sent to the requesting authority and say, well, when you need to answer this question, this is how it should be done. So a good recent example of this type of opinion is what we did last year on AI training. You may have heard about this opinion. It's a request by the Irish authority. They ask a number of questions. We answer these questions, and then they can implement this in their enforcement practice. Another type of Article 64 opinion is what we do on, for instance, draft codes of conduct. And I'm mentioning this because there's been draft codes of conduct relating to clinical trials, for instance. So when a code of conduct or another example, I think this was mentioned too, data protection impact assessment lists are prepared at national level. The national authority prepares this, sends the draft to the EDPB, and the EDPB checks whether or not what is being prepared as a draft at national level respects the general rules that are applied by all the others. And if not, the EDPB asks this national authority to change their draft decision in a specific way. So either in the case of the DPIA, change this item in your DPIA list, or if it's a draft code of conduct, change this and that before you approve the code of conduct at national level. So these are different instruments to build consistency. Now, Michael mentioned something else, which is the one-stop shop register. So it's the register of the cases that were decided by the authorities on cross-border cases. If you type the right keywords in your favorite search engine, you will find this, and it's a publication of the different decisions. So what the authorities have decided in practice, the case law, if you want, of the data protection authorities, and there's a search engine that helps you to find, you know, depending on the article that you're interested in, find the decisions that were adopted by the authorities on that specific subject. Another thing, and I won't be too long,
No, go on.
another thing that we are doing at EDPB and we committed to is to increase stakeholder engagement. And there's a statement adopted by all the commissioners after a meeting they had in July this year, where we say that we're going to enhance consultations, explaining how we take consultations into account, organizing events with stakeholders, checking and monitoring, enhancing the way we monitor how the guidelines are being implemented at national level, because this is the key mission of the EDPB, which is to ensure that the EDPB, the GDPR is applied in a consistent way across the EU.
Thank you so much. I think it's kind of interesting, especially regarding the register, because I had some cases where I was, wondering how, member state, in particular, supervisory authority in member state has, different approach and how to take into consideration what you advise, a client that operate cross-border. And I think the register can provide an answer, because at the end of the day, it's a kind of aligned position of, all the supervisory authorities. So it means that if that register contains decision or positions on anonymization, can we base our assessment on that and consider that it's the view of all the member states? I think that's quite interesting for industries. So thank you for that. Now I will turn to you, Marta. Okay, we can anonymize. We have the relative approach of anonymization. So it's possible, but I'm wondering, is it always the things to do when it comes to medical research, especially when it comes to, based on your experience, is it possible to have specific legislation that prevents you to choose that option, for example? Or, based on your own experience, do you think in any situation, any research, is it suitable to go for anonymization?
So is it strictly prohibited, or is it used?
Yeah, based on, for example, let's take clinical trials, and since we say, okay, anonymization should be assessed in the hands of the person that holds the data, and you're in clinical trials. Is it? Do you have legislation, like for example, clinical trial regulation that will prevent you to rely on anonymization because you need to keep the link between the participant, for example, and and the data, or something like that?
Of course.
Yeah.
So to start with that, yes, indeed, when it comes to the data from clinical trials, the data must be retained in a coded format, which we consider usually as pseudonymized, for at least 25 years, as per the European Clinical Trial Regulation. So we cannot entirely anonymize the data and keep only anonymized data instead of coded, because we have regulatory obligations that we have to comply with. However, data might be still need to be anonymized depending on the additional purposes. So as Patrice nicely said in his presentation, health data can save lives, and there is a lot of value in the data coming from the clinical trials. And data that we collect, or pharma companies collect in a regular clinical trial process, might still be needed for or useful for other, a bit broader medical research purposes. And anonymization in such case is considered to be one of the data protection measures that can be applied, for instance, in case coded data is not needed, or in case maybe coded data should not be used for various reasons. And there is still a lot of value in such research performed with anonymized data, as it might, in certain cases, even allow us to avoid unnecessary clinical trials if we could learn already from the data that patients participating in the previously conducted clinical trials contributed. So indeed, that
and
can happen.
I will try to link that with something Patrice said in its recommendation regarding anonymization evaluation. He said something about try to know your recipient, try to identify the person you will share the data with. If you apply this to the clinical trial, especially when it comes to publish the result and so, what's your view on that? Is it can we rely on anonymization in the situation? I mean, if you want to publish the result at the end, what are your views on that?
Yes, so anonymization is, I think, quite broadly used in pharma industry, and there are cases where obviously coded data will be used, and that's the so-called primary purpose of data collection, where we perform the analysis as per the trial protocol, and then we prepare the clinical study report. All of that is performed on the coded data in accordance with the good clinical practice. And that is a very well established practice for many, many years. It's a global one, and here there is essentially not that many doubts that this data can be used for that purpose. But then, indeed, there are situations where data will be aggregated and anonymized in different ways, depending on the need. There is a variety of initiatives where pharma companies contribute with their data from clinical trials, supporting almost public scientific knowledge. And there are those voluntary data sharing programs where indeed anonymization will be performed. And here we go to the point that you have mentioned, meaning how to perform the anonymization appropriately and in accordance with all applicable standards. And indeed, the anonymization will be always contextual, and will also require certain additional measures to be applied. For instance, in case of sharing data with external researchers, there will be always, at minimum, contractual measures, and quite often also technical measures preventing even taking attempts to re-identify individuals. And this contextual anonymization will be always documented. The risk is always measured and must be below certain agreed threshold that is expected to meet all globally applicable criteria, also those more strict. And again, if context would change, the re-anonymization might need to be then performed or reassessed.
That's really interesting. If you allow me to ask you a last question, you talk about thresholds. Do you have guidance on that? Do you rely on, some non-standard, or is standard that you define yourself depending, for example, on the specificities of your research? I mean, how do you have in your practice concrete scenario where you need to do that exercise, or not at all?
I mean, by default, this exercise is done, meaning that there is a statistical analysis performed on the potential risk of re-identification, taking into account, among others, the context in which the data would be used. For instance, this know your recipient context, right? So it's different how the data would be anonymized. Or for instance, clinical study reports that do include also certain level of, by definition, coded clinical trial information. There are those patient listings or patient narratives describing adverse events that took place during the clinical trial. And so the clinical study report does include certain level of coded clinical trial participants' data. And in such form is submitted to the health authorities, of course, as per the applicable regulations. However, in Europe and in Canada, at certain point in time, those reports will be made publicly available. And for that purpose, again, the anonymization of the data, or reduction, I would say, to some extent must be performed in a way that the data or the report can be safely published. So again, depending on the context, for the public access, the anonymization will be performed differently than in case we would have some, let's say, form of a collaboration or request from the external scientists. And there is also a number of, for instance, European IMI initiatives where also data might be contributed by participants of that initiative. And there are also certain anonymization standards will have to be applied in accordance with the context of that collaboration.
Very interesting, thank you. I will ask, I think, only one question to Patrice because he spoke a lot. I mean, for me, you said a lot of things that was already agreed on, like, for example, the fact that absolute anonymization is a kind of myth, because when you see the text, nothing says that we should have risk zero when it comes to demonstrate an effective anonymization. Also, you said that you use the terms identifiability. I really like that because, I mean, last year we participated to the EDPB guidelines on pseudonymization, and we tried to explain that the duality between pseudonymization and anonymization was old, and we needed to think on the risk of re-identification and to make it like on top. Welcome.
Just to introduce Giuseppe D'Acquisto from the Italian Garante. So we will give you a few minutes to take your breath. Do you have any slides?
Yes, I have for the keynote.
Yes.
Yes, I have.
Then we can give them to the technician. Eric?
Yeah, so in the meantime, so we were discussing about that relative approach of anonymization. So, and you said that the EDPB guidelines already bring a lot of things regarding how pseudonymization is important, how we can help data minimization, and so on. But there is one extract from the EDPB guidelines on pseudonymization where they said when the key exists, because pseudonymization is about removing the key and take it in another database for security and so on. And they said when the key exists at some place, data will be pseudonymous, and so data will follow the GDPR. And I'm like, so at the same time, the CJ is saying pseudonymized data can be anonymized, but the EDPB says when the key exists, the data are pseudonymized, and then they are falling under the GDPR. Do you have any view on that?
Yeah, it goes back on insignificant risk and reasonable means. So I always advocate making practical assessment. So you have to make this assessment. And I haven't mentioned during my speech earlier, we are still using criteria that you probably all know. That's why I wasn't mentioning, but let's back to that. In the opinion from the WP29 on anonymization, we are still using the 3 criteria. And that's also a basis for this. You have to make it, and it works. And once again, it's not because there's a key somewhere that it's personal data. the definition of personal data is not if someone somewhere can link to an individual at any cost, it's personal data. It's not the definition. And that's what the SRB case is saying. And maybe it's just based on a decision from the European Data Protection Supervisor that has been maybe a bit too quick in going to that conclusion, saying pseudonymized data is personal data. And actually, the position of the court is maybe not contradicting what has been happening. It's just a lack of explanation and how you get there. Have you made the assessment on the recipients? That's a basic case. But there's also something I wanted to add. You do your assessment. You do the risk assessment on risk of identifiability. Then you end up in a case quite often where you say, I cannot really say it's anonymized. I cannot say 100% for sure. I'm certain it's anonymized. But it's still okay. It's just a question how to do it. We are not answering to the operational teams. Yeah, in that case, you can't. In most cases, you don't answer, we can't. There's ways. GDPR is actionable. Maybe you end up having personal data, but since you apply GDPR, and there's many possibilities, there's a lot of things that we can do, even if we have personal data. Pseudonymization is good as a safety, as a safeguard measures. It's the way GDPR made it. Pseudonymization is a security measure. That's the same with minimization. So two things on this. First, make it reasonable in the way you assess the risk, how you protect the data. Getting back on guidelines for AI training, if you look at the one from the CNIL, it says that quite often there will be personal data, but there's a way to still do it. If some people, when the AI Act was published, and that was the same when the medical device regulation was published, saying it's not possible, it's not compatible with GDPR. Yes, it is. That's the way it is. There's in 99% of the case, maybe even more, there's ways to comply with GDPR, with the AI Act, to do innovation, to apply that in the MDR context. There's a way. And think out of the box sometimes. Maybe you will need, at the end of the day, going to the, I don't know, one of the worst case scenarios. You have to build one of the health data warehouse that has been conceptualized by the CNIL. As a private company, it's far from easy because you need an authorization to do it. But maybe one of the solutions is taking the time, doing it correctly, and build one of these health data warehouse. The CNIL itself gives us tool to create a kind of ethical health data brokering tool. We can do it. It's just that proper safeguards should be implemented. So do your risk assessment. Think about the real criteria from Working Party 29, from the Olaf case. There's all these criteria to take into consideration. And if at the end of the assessment we have personal data, implement correct measures to pseudonymize, minimize, protect the data, and there's a way. It's very rare, really, it's really not often that the answer to the question from the operational teams is no, we can't.
Okay, thank you. So also something interesting there is the need to involve data protection authorities to your risk assessment. Talking about data protection authorities, I will give the floor to Giuseppe for his speech. I don't know if you want to. You can stay there or you can sit. I mean, do as you want.
You can use this to move the
Okay. Okay, thank you. Okay, first of all, big apologies for all this mess determined by, let's say, my travel from Brussels today. I was in Brussels for the monthly meeting that we have within the EDPB, so my apologies. And also, I'm thankful to Pierre-Yves for having me today to talk about pseudonymization, and also to Wendell Legrand, my colleague, who suggested my name for this intervention, which actually puts me in a slightly uncomfortable situation for all the reasons that were touched in previous interventions, I'm sure, because we all know that we have this SRB ruling, which has given important clarifications on the notion of pseudonymization. The topic has become quite hot, and I believe that this is the reason why Gwendal did this favor to me to suggest my name. And the tendency which I observe is that there is, let's say, a sort of tendency towards oversimplification, which is not the right approach. So my ambitious goal today is to avoid any vagueness, because vagueness is the real enemy here. And we are in front of complex topics, and the key for complexity is not to turn our head around or to put the dust under the carpet, but to face complexity and provide solution. This is the ambitious goal of my presentation today. So it will be very, very boring, and I will start with, let's say, the outline of the presentation. And my plan is to start with the definition that we find in Article 4.5 of the GDPR, which already by itself provides a lot of practical guidance on how pseudonymization should be interpreted and implemented. Then I will speak about the components of pseudonymization, which are the pseudonymized data, which is a notion which doesn't exist in the GDPR and has been several times mentioned in the SRB ruling, and the additional information. I will talk a bit about these two components. Then this notion of pseudonymization domain, which is a new concept introduced in the guidelines, which has attracted a lot of attention and also raised some criticisms. I will try to, let's say, explain what we meant when we introduced this term. Then the use of pseudonymization as an effective way to implement data protection principles, which actually is the right way to look at this practice, and the benefits for the data controller, which essentially consist in extending the life of the data and use the data for a new scope, maybe beyond the original one. And finally, some good practices also drawn from my experience in Italy. The Garante has worked extensively in the area of pseudonymization. We have gathered quite an extensive experience in the area of health and scientific research, and I will present some ideas that we have prescribed to data controllers in Italy. So I will start with the definition. You all know this definition. I will not read it. I believe it's the most appropriate way to tackle the problem. The GDPR defines pseudonymization as a processing operation, which has the characteristics that you all know. The processing is, let's say, carried out in such a way that the original data cannot be attributed to a specific data subject without the use of the additional information, provided that this information is securely kept. It's a definition of a process in which we have, I draw your attention on at least two objects, like two pieces of a broken medal. Okay, I will use this metaphor. We break this medal in two parts. One part is kept at home, and the other one is shared with other, let's say, entities. Now, identification, which means the attribution of the data to a person, is possible when the two pieces of the medal are joined. And if this metaphor works, when it comes to be practical and implementing this concept, we have actually infinite variants of breaking this medal into pieces. And if we make it simple, not necessarily this simplistic implementation of this process fully meet the requirements in the definition of the GDPR. And this before looking at the guidelines or at the ruling. I would like to emphasize this important step. One single outcome of this process, namely the famous half medal I mentioned earlier, which we might start calling pseudonymized data along the line of the ruling, cannot be used to identify a person. It cannot be attributed per se to a data subject. This is a necessary condition for pseudonymization, and it comes from Article 4 without looking at the guidelines or the ruling, and this is a necessary condition. Okay, details are extremely important. So just looking at the definition, I personally draw two messages. First, the conjunction of these two outcomes generates a personal data. This is what the definition says. And if we deflect from this process and consider just a partial outcome of the process, for instance, we consider this single half medal in isolation, we are in a domain with infinite variance, and we must clearly specify what we mean by this partial outcome. If we don't do this, I fear that we might run the risk of misunderstanding and the risk of being trapped in errors. Now, let's go to, I believe, the heart of the matter with this example. Well, actually, pseudonymization as a concept has been there for quite some time, before even the GDPR, before the 2014 Working Party opinion, of which I carried the responsibility because I was the rapporteur and basically the writer of that document. The common understanding of this notion is that we replace the identity of an individual, let's say name and surname, with an attribute which cannot be understood. It's unintelligible. For instance, a hash, like in this slide. What's the characteristic of this process? That starting from the hash, you cannot get back to the identity of the individual which has generated this hash. Now, the guidelines encourage us all to have a closer look at the structure of the data and not focus only or too much on the unintelligibility of the pseudonym. Now, let's look at this example. If you just look at the identity or the pseudonym, which is a hash of the real identity of the person, I believe that none of you can say who on earth was this person whose hash is the one that you see here displayed. But if you look at the other parts of the data, and you try to Google, I see that many of you have, devices. Hope they help in, let's say, being attentive. If you Google Anchiano, 15 April 1452, scientist and artist, I think that there's no doubt that the person we are referring to is Leonardo da Vinci. Does the effectiveness of pseudonymization relate only on the way we substitute the identity with an hash? Let's imagine a very extreme situation, very extreme, of course, very stretched and hyperbolic. I'm aware of this. Imagine that you have a law which prevents attempting to identify the person from the hash. There is an army which surrounds the safe where the key is stored. I believe that this is an unreasonable option to try to open the safe and take the key and restore the identity. But it's so simple. You don't need anything else than the other part which is untouched. So I believe, would you say that this implementation is a pseudonymization along the line of the definition, not even touching the ruling, not even touching the guidelines? I don't believe so. So before giving the label of pseudonymized data to a something, to an object, bear in mind this example. I leave the slides to you all to bring them at home and hang it on the wall, because I believe that this is a good example to not to be trapped in easy mistakes. Unfortunately, in practice, we have plenty of this implementation, and controllers pretend that this is a pseudonymization. Okay, they call this a pseudonymization. It is not. Why? Because we just focus on security. We focus on the security of the transformation, name, pseudonyms. It's more. Pseudonymization is more. At least security is important. Don't get me wrong. It's an important aspect of pseudonymization. But there is another component of pseudonymization which is extremely important, if not more important than security, which is data protection engineering. Data protection engineering is all you have to do in order to work on the remaining part of the record and respect the criteria in the definition, which tell you that the part that you spread out, if you want to call this pseudonymized data, per se, should not allow the attribution of the data to the person. So you have to do something more, not just hashing with hash with the best algorithm in class, the identity of the person. You have to work also on this other part if you want to meet those requirements, which overlap with the requirements of the judge. There's no conflict here. I'm here to pour water on the fire. There's no fire, there's no conflict, everything is compatible. What we have said in the past is entirely compatible with what the judges say today. From my perspective, I guess that Wendell is with me, there's no surprise. There's no new thing, it's just a matter of talking each other to better understand what we meant. And one aspect which is relevant in the understanding of the guidelines is this infamous notion of pseudonymization domain, which is an easy notion, which is the set of entities which receive the data. The ones who receive the broken medal, it's just a matter of giving a name to this. So we received a lot of criticism. We are in a context of a public consultation. We received more than 60 contributions, and many said, okay, why the EDPB is including a term which is not in the law? Come on. Come on. And this is where data protection engineering is very important, because we have to assess the very limited time I was with you. I already heard mentioning risk assessment. We have to do a risk assessment, and the starting point of risk assessment is how much information, how much capability the recipient has in order to, working on the half medal that he receives, identify the person behind the data. And of course this entails some choice, some strategic and design choice, which must be reflected in the way the record of Leonardo da Vinci is processed before it is spread out. And depending on the assessment that we do, meaning that depending on what we believe is in the hands of the recipient to try to make this attribution, we have to do different things on the data. So back to that hyperbolic and stretched example, if I want to distribute the data to, if my pseudonymization domain for the data of Leonardo da Vinci consists in persons who live in planet Mars, where possibly Leonardo da Vinci is not known and they don't have Google and so on and so forth. Maybe that simplistic way to pseudonymize is a good one, because actually they don't have the means to restore the identity. But if you distribute the data of Leonardo da Vinci to people living in Italy or in France, where Leonardo da Vinci is well known, is Italian, and maybe you have to do a little bit more. So there are many options to do more in order to mitigate as much as possible the risk of attribution, and this something more is a mix of two interventions. One in terms of security, and another one in terms of data protection engineering. Unfortunately, there is no time to go more in details on the aspects of this engineering, but if you read the guidelines, you will find a lot of inspiration on how to proceed. Now, benefits for data controllers. Why using pseudonymization? What is pseudonymization for? Well, I believe that the real reason why controllers should implement pseudonymization is because this is a compliance instrument. That's what the law says. Article 25 says that pseudonymization is a way to make data protection principles effective. What does it mean? That controllers should not only get inspiration from the principle. You read the principles in Article 5 and you are inspired to behave. No, they must be accountable, and they have to transform this inspiration in something which can be measurable. So pseudonymization is a way to make this inspiration and this implementation of principles tangible. It's not just a security measure, as I heard before. Allow me to say that this is the easiest way to interpret this notion. It is, of course it is, because if you transform an identity into a pseudonym, you increase confidentiality. Of course, you make the data more confidential, but it's more. And in the health sector, this is very relevant. Consider, for instance, QR codes. QR codes, which are pseudonym, are a way to make data more, let's say, robust. They resist more to tampering, alteration. Imagine, let's say, the patient's name on a test tube, on a probe tube, which is handwritten by a doctor. Would it be so secure and safe compared to a QR code? Of course, QR code, if it's read by a machine, is much more reliable. So it's a way to make data more integer. It's more because, for instance, in the guidelines there is this term cryptographic commitment, which is sort of nested multilateral pseudonymization, where multiple parties with multiple keys do this activity, this operation, and in doing this, they transform the data. They minimize the data so well to the extent that the data become a single-purpose data. So in this way, they get as much as possible close to the goal of the principle of storage limitation and purpose limitation, also in context where the implementation of these principles is very, very difficult. Think of blockchain, for instance. The data is there forever, and you have to comply with the storage limitation principle. How do you do this? In the CNIL guidelines, which inspired us all, dated 2019, they say that in order of preference, controllers should prefer the cryptographic commitments when loading the data onto the blockchains. So in doing this, what's the gain for controllers? This one, enabling the possibility to invoke legitimate interest, which doesn't fit very much with the health sector, but it's relevant in other situations, and also to invoke the possibility to give new life to data in this compatibility possibility that we have in Article 4. Data can be reused for a compatible purpose, and one of the elements in this compatibility test is the implementation of technical measures. Among those measures, encryption and also pseudonymization can can be mentioned. It's a safeguard in the case of international transfer. There is an opinion of there are guidelines of the EDPB in this respect, and there is another context in which pseudonymization has a role, which is the area of processing operation which don't require identification. They are regulated under Article 11. When a controller cannot identify a data subject, some rights are suspended. I guess that you all know this. Articles from 15 to 20 are suspended, but if the individual can, let's say, at a later stage, provide an identifying element, and the pseudonym is an identifying element, all these rights are restored and reactivated. It enables new way to talk. It enables new way of dialogue between the data controller and the data subjects. Good practices are extremely important, but they should not be taken as a tick the box exercise. Here we don't have silver bullet, we don't have solutions which fit for every situation. There's no checklist of mechanical things to do without too much thinking. There are good practices, but they have to be implemented with this spirit. I must be aware of what I'm doing. I must be aware of what I can get from those measures. So I believe that these are the two main areas in which you can really come out with a very good, substantial, and effective pseudonymization. Security engineering, meaning what you can do at home before the data, the medal is broken and half of this medal is spread out, and data protection engineering, as said, which applies to the data which goes out from the premise of the controller and is distributed within the pseudonymization domain. Let me give you just a few words on these practices, which we use a lot at the Garante in Italy, in the health sector, in statistical research, wherever. This has become the way we interpret pseudonymization in Italy, and this is the way I try to, let's say, convince colleagues from other jurisdictions that this should be the way to implement this practice. It's not just replacing identity with an intelligible code, but in any case, as I said, security matters. So the stronger the hash, the better it is, of course. And one very important goal to reach is unidirectionality of this transformation, meaning that starting from the code, you should not get back to the identity which has generated the code itself. But there are other elements which are extremely important. For instance, avoiding patterns, meaning that it's better if you eliminate any sequencing, ordering from a table, from a set of records, which might allow indirect identification. If John comes after Mary, if you know that Mary is there, John is the second after Mary, so in such a way you have identified indirectly one of them. Use high entropy spaces, meaning, as you can imagine, substituting Leonardo da Vinci with LDV or Guendal Legrand with GLG is a very bad, let's say, design choice. Much better if we use very long sequences of pseudo-random alphanumeric symbols, like hashes, which provide much stronger protection. And also, for instance, another good practice that we normally prescribe is introduce a hierarchy between pseudonyms. Pseudonyms is not a scarce resource. There is plenty. There is abundance of pseudonyms. You can, don't be greedy. Use them as much as possible because we have plenty of pseudonyms. And if you look at the issue with this, let's say, with fresh eyes and considering that this is an abundant resource, maybe including hierarchies, you made a couple contexts, because if John Smith has two different pseudonyms referring to a unique root, you have to go through the root in order to reconcile two contexts. And this also generates governance, because if you want to reconcile, you have to go to the upper level where possibly there is a responsibility which, let's say, enables this joining. And also another good practice is the rotation of pseudonyms over time, which, let's say, breaks the links and mitigates the risk of very lengthy longitudinal tracking of patients, for instance, in the health sector. And it's not just that. Normally people, I would be very happy if they stopped there, but with all the due consideration to these goals, but we need to do more, and I would suggest second reading of the Working Party 2014 opinion, where these are the two main, let's say, interventions if we want to downgrade the power of identification of the data. Randomization, generalization, what does it mean in practical terms? That if we want to have a good pseudonymized data of Leonardo da Vinci, we should remove the city with the region, Tuscany, maybe not the exact date 1452, but from 1450 to 1500s. And if we do so, we discover that in Tuscany there were plenty of geniuses at that time, but if we enlarge a bit the let's say the size of the sets, so represented in Tuscany, but in that period it was also Piero della Francesca, and there was Simone di Giorgio Martini. There were plenty of geniuses who were scientists and artists. Or generalization, as said, and also randomization, which means that maybe I can, let's say, manipulate a bit the data points. I move them from here to there. I, let's say, swap. I do something in order not to include what we call plausible deniability. If someone say this data belongs to you, I can let's say object and say no, this data does not belong to me because I can prove you that this is not my data. So it's a mixture of these two interventions which makes the pseudonymization effective. Now, let me conclude with a reference to the elephant in the room, which is the ruling of the Court of Justice. If you ask me, is there a conflict between the guidelines and the EDPB? I would say not at all. We don't have the time to read this. I'm quite sure that you have already, let's say, gone through this document several times. This is my point in the ruling, which is section 77, where essentially the judge says that there are measures. This is what the judge says. Which can be put in place by the data controller, which have an effect that for the recipient, the data, the pseudonymized data, this is the term that the judge uses, is not personal in nature. I want to highlight one thing. The judge says that these measures exist, but he doesn't say what these measures are. So essentially, it's up to the General Court to check whether the measures put in place by SRB were sufficient for the scope. So we know that they exist, they are in the air, but then the judge doesn't go to the extent to say what these rules are. It's up to us to identify those rules and put them in practice, and provided that the recipient cannot lift those measures. The recipient cannot alter what the controller has done at home, and the half part of the medal is per se not capable does not, let's say, allow attribution and identification to the person. From my perspective, these considerations can be fully subscribed. They are perfectly compatible with the spirit of the GDPR. They are perfectly compatible with the guidelines and do not sound like a surprise at all. The crucial point and the concern is that this ruling should not be read as a rush to the bottom. This is not allowed. It's not allowed to to be simplistic. I believe that the right reading of the ruling is that it's not anymore time for simplistic implementation of pseudonymization, which don't help at all. Let's be frank, pseudonymization is possible, but it's difficult. We have to be aware of this, and we are working hard. I'm coming from Brussels this morning. We were discussing about this point, and we are working hard in this context. We are in the context of a public consultation. It has been announced that in December the EDPB will organize the stakeholders event to collect further inputs. So from our perspective, we want to make this framework within which pseudonymization should be, let's say, read even clearer if possible, and this exercise, which is difficult, possibly less difficult for data controllers. So that's it. Thank you very much.
Yeah, I think unfortunately for time constraint, we will not be able to receive questions, but feel free.
I think we need to at least have a few questions.
Thank you so
because
much.
I think
Yes, thank you.
our audience will be frustrated as always.
Yeah, thank you so much.
So who has a...
How many questions can I ask?
Try to ask one question.
Thank you. This is Xiao from URTC. Thank you very much for your great presentation, and I'm very amazed that we can put together the case laws and to make it clear the notion of pseudonymization. And I'm also personally very much like the handbook proposed by Patrice, and I must say from the SRB case and the suggestions you proposed, it's also very much controller-centered. So what I wish to see more is your suggestions on the side of data recipient. So here I actually have a few layers of questions, if I may. So for the data controller for each data sharing, obviously you said we need to make risk assessment, and this must include the ease for re-identification. But there's a limitation of the information accessible by the data controller. So on that, immediately I think about due diligence. How can we get information from the data recipient for us to assess the ease of re-identification? And then on the recipient side, if I am the data recipient and I'm receiving pseudonymized data, I would not argue it's not personal data, because I would need to prove that. So is it true that for data recipient, the safest approach is still a conservative approach, is to comply with the GDPR? And in this sense, as data recipient, must they still assess the ease of re-identification? And to do that, the only way is attempting to re-identify. So what is your take on that?
So maybe I can start, and if anyone wants to chip in, just can take the mic after that. So that's an excellent question.
Speak in the mic, because...
Yeah. Is it working, actually? Yeah, it's working. Okay. So excellent question. So data recipient. The recipient, it's not exactly defined by GDPR. It's not one of the roles that you can have under GDPR. So as a data recipient, in most cases that you envisage, you're a controller if it's personal data. So you have to make the assessment. You have to determine, are you a controller? So do you receive personal data? But it's also about trust. Do you trust what your source is saying? So your source will quite often say, no, don't worry, that's anonymized data. But you still have to make the assessment. Question is, until which point do you have to go? It's not that easy. As a data recipient, you may not have all the information necessary to do it. It can be extremely costly. There's also a matter of time and rush. Quite often in many of the projects you receive the data, you want to believe your source that says it's anonymized. So quite often, it's a question of trust. If in front of you, you have a big company, a big public body, I don't know, major hospital group, telling you, this is anonymized data that I'm providing to you as a data recipient. Then, question is, can you really defend that you believed, in case of investigation, there's an investigation by the Data Protection Authority, can you really sustain, support, show, demonstrate that you can really believe into this assessment that it's anonymous data? So if it's a big group, a big public body, someone, let's say, that should be reliable, you need contracts, you need provision in your contracts, making that sure, and not just it's anonymized data, it's data sharing with anonymized data. A bit more, like it's anonymized data according to the criteria under the GDPR, and so on and so on. You still have to do an assessment on your side. But for anyone familiar with French civil law, civil obligation, you do not have, as a controller, in my view, an obligation of result. Call that obligation of result. It's you just have to demonstrate that you have put in place proper means to make sure that it's anonymized. So you have the contract, you receive the data. If obviously it's not anonymized, it's personal data, then you have to do something. There's practical means to assess. You can build a kind of black room where you will have a selected team under NDA checking the data, checking a sample of the data, making sure that it's anonymized as much as possible. And then there's option 2. You receive data from some, I don't know, shabby little startup company in an obscure country that do not know anything about GDPR, and they are telling you, yeah, I'm selling data to you very cheap, and of course it's anonymized. Then I will say that your threshold of making sure that it's true and it's personal goes up. So you have to add additional measures, additional verification to make that true. Once again, you have 2 goals: making sure that you comply, obviously, and if you have an investigation, you have to show what you have done. Not taking that just at face value. You have to show that you have implemented proper security, proper measures, proper safeguards to make sure that it's anonymized. And then if it's personal data, it's another story.
I think we need, unfortunately, the time is running very fast. We have 2 other sessions afterwards. So what I would propose is that you ask the people directly in during the coffee break, because we have one session starting at 4:30, so in 23 minutes, and then afterwards we will have another session with oral communication, with very interesting topics. For example, using AI to improve anonymization, or using AI to break anonymization. And so I think that there is still a lot to discuss. I want to thank all the speakers. Thank you very much. Thank you for your attention. Take your time for a bio break and coffee break, and come back at 4:30, please.